including Jacob Wagner and Alana Uggan from the Attorney General's office. But I assume Attorney General Doug Moylan, you'll be providing formal testimony on behalf of your office.
Yes, I will.
Please proceed. Thank you.
Anthony, Senator Brown, Senator Barnett, and Senator Fisher. This testimony is submitted on behalf of myself and our client, the people of Guam, in opposition to Bill number 30637. Simply put, we believe this bill is a solution in search of a problem and creates an irresolvable dilemma for the judiciary. We support efforts to make our judicial system fairer and more equitable. This bill in its present form asks prosecutors to disclose undefined information and asks judges to resolve questions that haven't been asked. The job of a prosecutor is to enforce Guam's criminal laws and to do justice. The function of our judges are to impartially interpret and to apply the law. This bill in its present form requires the people in the government to potentially needlessly put into the public record facts about a defendant that damages their reputation beyond the fact that they've been arrested and will greatly impede their efforts to achieve a speedy trial. Let's parse the new language in the bill, and I'll make the point. The bill asks for a disclosure of certain information that may be used to impeach the credibility of a defendant. Impeach the credibility to a non-lawyer means to call the defendant a liar or to question their credibility. Whenever someone testifies in a trial, it's the job of opposing counsel to bring out not only the facts of a witness may have left out, but also the witness's biases and motivations in testifying. We want juries to hear testimony, but we also want juries to have as much information as possible with which to weigh the value of someone's testimony. So to some extent, the job of opposing counsel is to call a witness for the other side a liar and to prove it. Criminal defendants have the constitutional right to not testify in their trials, and they almost never do. The reason is that if the defendant testifies, then the prosecutor gets to impeach them by asking them questions the defendant may not want to answer, such as why that person may have lived a life of crime in their prior criminal acts, and that sort of information. The bill asks the prosecutor to enter into the public record all uncharged past criminal acts and vicious or immoral conduct which the prosecutor might use to impeach the defendant's testimony. Even though it's rare that a defendant might testify, this bill will require that in all criminal trials the prosecutor must put into the public record the bad acts the prosecutor can dig up about the defendant. Consequently, even where a person is found not guilty and never testifies, the Attorney General's office will still put into the public record all information a defendant may not wish to have disclosed. I choose the examples to illustrate another problem with the bill. Exactly what is the definition of vicious or immoral conduct? Many will say that an act is vicious, while some may say it is not. Some believe skipping Mass is immoral. Is that what needs to be disclosed? The finer point here is that attorneys and judges need to be clear and to be made clear unequivocal rules for trial. Because if the rules aren't clear, then the arguing will never stop between counsels. The bill also asks a judge to rule on the admissibility of this impossible impeachment evidence before the trial even starts. The two principal rules of evidence are that things need to be relevant and that the person testifying should have first-hand knowledge of the things they are testifying about. Even assuming that the defendant in a trial might be listed as potential witnesses, if defense counsel does put them on the stand, they will only ask their client to testify to facts and circumstances that are advantageous to the points of counsel is trying to make. But defense counsel doesn't know what points they want to make until they hear the prosecution's case. And the prosecution won't know what a testifying defendant might be lying about until they testify, or how the prosecutor might otherwise impeach the defendant's testimony until the defendant testifies. However, this bill requires the prosecution to disclose every bad act known about the defendant because the disclosure has to come before anyone hears any testimony. This bill also asks the impossibility out of a judge, requiring the judge to decide admissibility of impeachment evidence before the judge or anyone else hears the testimony from the person, the defendant. That's not fair to the prosecution or to the judge, but it's really not fair to the defendant, who likely won't even testify or won't ever have the truthfulness of any testimony challenged. Why put things in the public record that only create more problems than it solves? We suggest that the first thing every legislature should ask about every bill is, what problem are we solving here? I don't know what problem this bill solves. It also asks for disclosure of ambiguous information that will only serve to create endless pretrial hearings and delay the opportunity for victims to receive justice. The bill focuses on a situation, criminal defendants testifying in their own trials, that may never happen. Senators, I'm going to address this issue very lightly. You have an active defense attorney introducing a bill that is undermining and causing greater burdens upon the people of Guam's attorneys. I object as the Attorney General that a defense attorney is using his office in order to write bills and present it to the legislature that undermine the people of Guam's legal interests. The author of this bill has divided loyalties. He has a loyalty to criminal defendant and a loyalty to the people of Guam. I believe that, in addition to that, where is the draft model legislation that this is following? The Superior Court of Guam and the judiciary have an elaborate set of existing rules that do not require this, and they've been in our books for probably at least 50 years since the code may have been adopted from California. Another problem with this bill, potentially, and I believe there are exceptions, but with the passage of the Organic Act, the Supreme Court of Guam normally makes its own rules when it comes to evidence. The Guam Rules of Evidence appears to be something that should be more appropriately adopted within the Guam Rules of Evidence and not being put into a statute form. That issue, I think, needs to be further researched because this clearly appears to address the admissibility of evidence, the requirements of disclosure to a certain extent, and I would object because as the office had earlier pointed out, it's costing the taxpayers at least $240,000 more in an office where there's not enough lawyers on Guam. Our budget was not increased. This is essentially an unfunded mandate unless there's going to be a supplemental appropriation to the AG's office, requiring greater burdens on potentially delaying, and it will delay the current movement of cases through the criminal cases through the judiciary. You're creating more of a basis in which defense counsels will object, will be appealing these evidentiary type of rulings, and further frustrate an already overcrowded criminal justice system and the dockets for the judges, of which there are only 4 full-time criminal court justices of the 7 that are handling an already COVID-afflicted, burdened criminal docket. With that, Senators, our office opposes the legislation and believes that it is inappropriate for a defense attorney to be drafting legislation against the Office of the Attorney General. Thank you.
Thank you very much, Attorney General Moylan, for providing your testimony and also providing your written testimony with regards to Bill 306. With that, we'll certainly have Senator Fisher as the main sponsor. Do you have any questions or comments you would like to make?
Yes, I do, ma'am. Thank you very much. The first thing I need to point out, I think that the Attorney General is under a bit of a misunderstanding. This is not a rule of evidence. This is a rule of criminal procedure. They're quite different. This is requiring disclosure of information that is almost certainly in the AG's hands. I just have to comment on this $250,000 bill they've attached to it. I assume that the Attorney General was able to didn't just pull this number out of their hat, that he must have crunched some numbers to determine that, and we would be happy to look over that analysis from the Office of the Attorney General. I think that is fanciful to say that this is going to cost any more at all, because it is the job of the investigators, and it is the job of the police force, and it's the job of the Attorney General's assistants to gather the evidence that they intend to use. They don't have to gather evidence they don't intend to use. All of this that they are required to disclose is in their hands. I think raising this canard of $240,000 bill is offered just as an additional burden that simply does not exist. But Mr. Morrison, you heard me. There are people, I suppose, at home who may be watching this who are not practitioners, and I have just recently said that this is a rule of procedure and not a rule of evidence. When I say rule of evidence, what do I mean by that?
Well, you mean, I think you mean...
In the event that they choose to testify.
No, it won't, because we already have an obligation to provide all the evidence in advance of trial.
To support body cams, it protects them. I think also it's the exact same theory, supports the police officers in their work in interviewing and conducting interrogations. They will avoid the, as you and I have heard many, many times, allegations of police misconduct, and they beat it out of me, and I didn't see it, and I can't speak it. You've heard the litany, and some of it's true, but by and large, it's not. And I think that your idea of making this a foundational requirement would really help Guam Police Department, and it would also have the knock-on effect of helping the community. And so I thank you for those suggestions, but I would like to ask the Attorney General of Guam some questions about his testimony. Sir, thank you for the written testimony. I've had an opportunity to review it. I know what your answer will be on this, but I'm going to ask it anyway. It's kind of rhetorical, I guess. But do you agree that the burden of proof remains with the government, as well as the burden of going forward in a criminal trial?
Senator, the burden of persuasion and the burden of proof are upon the people, the government's attorneys. That's correct.
Okay. Thank you. This bill, sir, is defined to make the rules of disclosure more transparent and make for the defendant, make a choice clearer, testify or not testify. Do you agree with that?
No.
Did you see that? You can also easily measure the area of any room. You can count the number of any objects.
Do you agree with that?
No, I don't. I think that the existing rules require that the government, in meeting the burden of proof and the burden of persuasion, which is beyond a reasonable doubt, for the burden of proof, that if you intend to convict a citizen, that you must disclose that information in advance at trial. You're adding you're trying to make the prosecution do work that the prosecution might not choose to do to convict your client.
Okay. Well,
and again, I object to the fact that I'm being questioned by a defense attorney sitting as a senator of this legislature.
Understood. Your objection is on the record, and I'm sure it's been registered by the committee itself. But going back to the question, now, this bill will illuminate for a defendant what it is the government intends to use in the event that they choose to testify.
No, it won't, because we already have an obligation to provide all the evidence in advance of trial of all of the evidence we intend to use at trial. We're not here to be doing the work of Defense Attorney Fisher or Defense Attorney Morrison. The rules are already in the books, and the government will be sanctioned if we do not provide all the evidence we intend to use at trial, exculpatory evidence that can prove the innocence of the defendant. Why are we doing these additional steps that's going to cost the taxpayers, the people of Guam, more money and threaten the safety of the crime victims? You're making it harder for me and my prosecutors to prove our case, doing the administrative work that should be done by the defense attorney, by yourself, Mr. Fisher.
How would, okay, well, I don't want to quibble with you, but I'm just wondering how a defense attorney would do that work, since it's entirely the choice of the government on which evidence they choose to introduce.
We have everybody's social security numbers. We have all the histories in the government records. If you expect the prosecutors to be doing your homework, Defense Attorney Fisher, I object. Where is the model legislation that you patterned this after? You're creating new requirements that I've never seen before as an attorney of 33 years, all these requirements, and that's why I say they look like evidentiary rules, because you're going down the list of basically like a civil discovery. Any written record of statement of substance of any oral statement made by defendant or co-defendant, if the trial is to be a joint one, any report or statement of an expert made in connection. Some of these things are already covered if it's going to be used by the prosecution. You're also showing the hand that if the defendant takes the stand and says something, you're preventing us from telling the defendant what we have to impeach him. You would raise it as examination, a direct examination. The prosecution would have the right to impeach your client on the questions that you've asked. Why are we having to show our hand as the people's attorney in advance of your questioning? Your list here of 8 different items, it's either covered by the existing disclosure rules.
When you say, sorry, I'm sorry to interrupt, but you said 8 items?
Well,
what are
8 categories.
Yeah, those are the rules of criminal procedure that have been adopted for years.
Right. So it's there.
Yeah, but they were adding a new one. Just to help you a little bit on that, sir, have you compared the rule of evidence 404B with this proposed law? 404B requires only general descriptions of the evidence the prosecutor intends to use. You can drive a truck through that loophole. This law, if it becomes law, sir, I think you will note, requires specific disclosures. And the purpose, of course, is to allow a defendant to say, well, I'm not going to testify. That will be particularly damaging, even though I am innocent. But I'll move on from that, sir. I think you made a statement. This is a bit of a, I'm paraphrasing for a bit. You said that the bill requires prosecutors to disclose undefined information.
Right.
And my question is, why would it be undefined where it is the Assistant Attorney General who chooses the evidence it wishes to use? They will specifically know the evidence. Far from being undefined, it is specifically defined, because the prosecutor, again, is the one who chooses the evidence. So I'm puzzled by that expression of yours.
On page 2, under the 8, you indicate vicious or immoral conduct of which the prosecutor has knowledge. What is vicious and what is immoral conduct?
That would be, well, sir, that would
Morality is defined according to religion normally. There's ethics, books written about what is moral, what is immoral. There's no definition of what a vicious or immoral conduct is. That was the reference.
Is there a definition of negligence? No.
Yes, there is. It's in the statutes, specifically in tort law.
It doesn't define what, anyway, okay, moving on. All right, sir. But the point being that it's the prosecutor who will choose the evidence. They will know perfectly what the evidence is. By no means would that ever be undefined. I noticed this comment. You worry about disclosing evidence that may damage reputation of a defendant. Isn't it true that the fact that you have charged them with a crime and that you have brought them into trial and you accuse them of a crime and you do so publicly, isn't that damaging to the reputation? And this bill, I mean, I'm going to borrow from Winston Churchill, isn't this a little bit like bouncing the rubble at that point?
The American justice system does not allow a prosecutor to bring any charge unless the people allow it to proceed, or a judge. When
No, sir, I have to interrupt on that. That is not the rule, sir. The American justice system requires you to have probable cause and believe you can prove the trial beyond a reasonable doubt. Yes, it does.
With all due respect, Senator, the criminal justice system requires that the Attorney General or District Attorney or whoever the charging authority is to review the evidence and put together the charges that will be cleansed through either a grand jury for purposes of felonies or for misdemeanors by a judge. There's safety measures put in place. No case number gets assigned to anything that the Attorney General puts together unless the magistrate judge believes that there's probable cause, that a crime has been committed, and that the defendant committed it. Not that the Attorney General believes that you committed it. We are a party before the bar of justice, as you know, Senator, Defense Attorney Fisher. When we go to the magistrate hearings every day, we put the paperwork together and the judge can either accept it or reject it. If he accepts it, he puts the case number on it and that proceeds to the next step, whether it's the grand jury, which is another safety measure so that the Attorney General or any individual that's a prosecutor cannot drag your name into court unless it's cleansed through the 21-person grand jury, that type of process. So that is why I say you are incorrect in saying that I drag anyone through the mud. It's the grand jury and the criminal justice system through the judges and the judiciary that authorize charges to go forward.
All right, thank you for that, sir. I just would point out that I'm not accusing you. I'm just quoting your words. You're the one who said that this would damage the reputation.
I said that if you require this bill, you're going to be putting additional information into the record that can damage their reputation. So in fact, it might be the author of the bill that's doing that.
Yes, sir. Let me ask, based on your recent statement, I just wanted to ask you a real quick question. Do you believe your prosecutors can file cases that they cannot prove?
I believe every prosecutor is a licensed professional like you are, Defense Attorney Fisher, that they have an individual obligation that when they look over the paperwork that they're exercising due legal capability on preparing those documents. There's ethical responsibilities for prosecutors as if for every other attorney on Guam.
Okay, all right. I'm happy to hear that. I'm happy to hear you say that, sir. It's one of the prime rules of our ethics that you not bring a case that you have no faith in and cannot prove. It's the kind of thing you should get tossed out for. Just a few more questions, sir. I'm going to look at your the letter you wrote in, you submitted.
Testimony?
Yeah, that's the one. This is your 1, 2, 3, 4, 5th paragraph. I just wanted to clarify what you said here. You said we want juries to hear testimony, but we also want juries to have as much information as possible with which to weigh the value of someone's testimony. When you said that, surely you meant admissible evidence.
You can create this glow fantasy effect using Filmora. Import your video and duplicate it. Then remove the background of the above video.
Well, that's the only thing that the judge will allow in so the jury can hear. When that proceeding begins, the judge is the arbiter of evidence that is admissible or inadmissible. And it's up to the defendant attorney or the prosecutor to move or to object.
Well, sir, I don't know that you've ever, perhaps you have, I don't know that you've ever prosecuted a case, but would you offer evidence that you didn't think was admissible just on the hope that it would get ignored?
I have no idea what you're saying, Senator.
Would you try and move inadmissible evidence into trial? That's a simple question, sir.
I will only move evidence that I believe is legally capable of being admitted and it's up to the opposite counsel
Okay.
to object to whether or not that's admissible.
Okay, that's fair.
And then it's up to the
that's
judge to
fair.
decide,
I
right?
agree. I agree with that. I just wanted to make
Well,
I just wanted to make clear that the Office of the Attorney General would never descend to such skullduggery as to try and get bad evidence in.
Senator, as a defense attorney who we oppose in court almost every week, I think that your comments are because you're a defense attorney. You're at odds with us every day, and I object that you're sitting here questioning me as the people's attorney. You are not acting in the people's best interest, with all due respect.
Yes, sir.
Attorney
okay.
Fisher.
But please be assured that this is all in the record. Okay, so none of it's being glossed over. But you did bring up a good point. What is the goal of the Attorney General's office? Get convictions or justice?
The goal of the Attorney General's office is to enforce Guam law that you senators pass. That is the obligation of the Attorney General, to enforce Guam law.
Okay.
The Chief Legal Officer of the Government of Guam.
Okay.
And justice is part of our ethical obligation as well. Whether we prosecute a case, whether we don't prosecute a case, what is in the interest of justice, what do the victims feel, whether we can prove our case. Those are all the things that go into the decision on when to charge a case, how to charge a case, whether to continue a case, whether to take a case to trial.
Okay, and then just a couple more questions. I'm referring to I guess it's your page 3, first full paragraph. It says, however, this bill, referring to the bill in question, requires the prosecutor to disclose every bad act known about the defendant. Why do you say that? That's clearly not true. It says that the prosecutor intends to use. Perhaps you're just being hyperbolic here, but I mean, that's simply not true, and I'm curious about why you would have included that statement. And the subsequent sentence says this bill also asks the impossible of a judge, requiring the judge to decide the admissibility of impeachment evidence. Sir, surely you're aware that judges do that every single day. This is not new by any stretch of the imagination. This is the judge's job, and I would just say to you, sir, that the bill, the point of the bill, is to provide clarity and allow one of our fellow citizens who is presumed innocent to make a better and more informed choice about how he will react to the prosecution and how he will confront the prosecution. So that's, I guess, ma'am, that's my comment on that. And I want to assure you, Mr. Moylan, or excuse me, Attorney General Moylan, that your comments on potential conflict of interest are on the record and they have been heard. And the 37th Guam Legislature actually has an ethics panel. I know of no reason that they couldn't entertain your allegation that I have a conflict of interest and ought to be either recused or precluded from acting on bills like this. I see nothing that would prevent you from making that complaint or making a complaint even to the Guam Ethics Office. So there is and also you have a right at the ballot box to get rid of me, right? So there are many off-ramps for your concern, sir. And I think, just on the general nature of a conflict of interest, I've always thought that in my professional capacity, sir, I've always thought that my principal job is having the privilege of being admitted to the bar. My primary duty is to ensure justice is done for the people of Guam and for my clients, and where let it fall where it may. But I certainly don't. I can't quite get the nature of the conflict you are alleging, that by doing things that I believe, or anybody would believe, were actually good for the people of Guam, somehow that I don't know, impeaches your ability to do your job, when I know for a fact that you are much more interested in achieving justice than you are in achieving mere convictions. So thank you for coming to testify today, all of you gentlemen, and ma'am, thank you very much for giving me the opportunity.
Thank you very much, Senator Fisher. With that, Senator Barnett, do you have any questions or comments with regards to Bill 306?
Thank you, Madam Chair. Mr. Attorney General, so obviously I'm not a lawyer, we're kind of outnumbered in this room, but just based on my research, the only place that I could find similar language to the bill that Attorney Fisher is offering was New York, but the language was subsequently repealed when New York replaced their criminal discovery laws. So I couldn't find this on the books anywhere in any state or territory. So I'd like to ask you, Mr. Attorney General, if you have any knowledge of this, these types, or this anything resembling this language in this bill being on the books anywhere else in the United States of America.
I am not aware of it. I had the team of prosecutors review this, and I was not involved in the calculation of how much it would cost our office. That was sent down to our accounting people in conjunction with the chief prosecutor on that question. Paragraph number 8 on the bill, I have no idea where that came from, and that's why I say in the law, most jurisdictions, they look to a model set of rules that define what is the fair rules of the game when we go into the prosecution and the defense of the defendants, because obviously they're innocent. Everybody's innocent until proven guilty. So this type of legislation, that's one of the big questions I have, and I have not had my staff meeting with the attorneys to discuss that, but I know as a defense attorney myself, I've never seen this type of language. Guam's codes were, I believe, the criminal code was initially adopted from California. Obviously that was decades ago, but long-winded response, I have not seen this before. But we haven't really delved into it either. So thank you for that New York reference.
Mr. Morrison?
Senator Barnett, I'm sure you won't mind, but some of my colleagues watching this are probably pulling their hair out. I do want to set the record straight and say that under Guam Rule of Professional Conduct 3.8a, there is an obligation that the prosecutor only brings a case if there's a probable cause. That's not to say that if a case gets dismissed for a lack of probable cause that they've acted unethically. Those things do happen, but the prosecutor must act in good faith. That's just the law, I think, or that's just the professional conduct rule on it. Now, as to your question regarding the specific language in here, you may not find it in a lot of other jurisdictions, and the reason's probably pretty simple, because those jurisdictions may have ended up in a case, and I know this because my home jurisdiction is one where this nightmare scenario has occurred, and then it's been on the Supreme Court or the appellate courts of that jurisdiction to figure out what do we do now. So they already know how to remedy the situation because case law is spoken on it. Now that's a long and cumbersome and potentially expensive process. Guam has not gone through that as it relates specifically to impeachment evidence after a defendant has testified, but other jurisdictions have the battle scars for us and have case law on it. Now, I don't think that this statute is very different than the case law that I'm familiar with that says the prosecutor must disclose impeachment evidence if they're aware of it when we're going through discovery. So if also on Guam currently, if you wanted to get an order from a judge that says this, you could file your discovery request and it would be pretty, I think they would grant it, they pretty routinely do, but this just sets out, I think, in a relatively straightforward way what should be required.
And if I may, Senator Barnett, to clarify, when I address this issue of probable cause, of course, the ethic rules do speak about the prosecutor's duty to ensure probable cause, but the guarantor of probable cause is the judge or a grand jury. So we present the case, but it's up to the judicial officers as well as the grand jurors to green light and to allow the case to go forward. They check it. They're a safety valve. That was the intent of what I was saying. Thank you.
Could I ask if you think that this bill is organic? Because I'm just looking at the Organic Act, and one of the powers of the local courts is to make and promulgate rules governing the administration of the judiciary and the practice and procedure in the courts of the judicial branch of Guam.
See, this is why I brought that up. I haven't done the legal research. This isn't a question that's been before us, but as a defense attorney and a prosecutor, it makes me question how far the judiciary can go in certain situations and how far the legislature can go. And I think that this is going into both realms potentially, what's being done here. So a defendant's right is normally afforded by the state, you know, in terms of what a defendant has a right to. But the evidentiary rules, which is what we're talking about here, what the jury gets to hear, sort of thing, the judiciary, the Guam Rules of Civil Procedure, the Guam Rules of Evidence, you know, you've got a non-organic act judiciary dealing with a pre-organic act legislature, pre-organic act affecting the judiciary legislature. So all the rules in the past were set by the legislature, and it's been over these past few years that they've been trying to decide which rules are still within the legislature's purview and which rules are not. One of the examples I would give is the 6107, what is it, 7 GCA 6107, the rules to disqualify a judge. Those rules are set by the legislature. And oftentimes the standards in which to disqualify a judge, like the appearance of impropriety standard, it seems to be most every jurisdiction that has the constitutional protection for the judiciary continues to allow the legislatures to set those type of rules. There's been a back and forth in terms of the rules of professional conduct. How much can the legislature say? How much can the judiciary say? As you can see with the power of the Attorney General, the duty to prosecute government officials and the duty also to render legal assistance to government officials, that's come into play. Where's the legislature's boundaries? Where is the court's boundaries? So this would require further legal research on whether or not it's infringing upon the judiciary's ability to set its own rules for procedures, and whether or not it affects actually the defendant's rights.
Yeah. Mr. Attorney General, if this bill should become law and the courts do find it organic, do you think that it would be one more avenue for Attorney Fisher's clients to overturn a conviction on the grounds that the trial court violated the rules of discovery?
Absolutely. And what I'm most concerned about is the pecuniary interest. When a defense attorney has a financial interest in receiving the money from any defendant that he's representing, let alone the ethical duty, that's where the conflict of interest questions come up. And that's why I'm concerned about this, and the fact that I'm spending our office resources having to defend that this bill should not be passed, and then the implications that if it is passed, a defense attorney has authored a bill that is now creating a greater burden upon my prosecutors and investigators and potential further litigation that will end up in the Supreme Court of Guam potentially. It's just unnecessary, and if you could show a model rule that this was drafted after, it would help us understand, is this a private motive for financial gain to pivot one of his current defendants into a better position getting to trial? My understanding is that Defense Attorney Fisher has several open cases that are before pre-trial. So this arguably could be used in favor of Defense Attorney Fisher for pecuniary gain against the Attorney General's office and my prosecutors.
Or he could also just be introducing it to benefit all of his criminal defense attorney buddies?
Exactly. Against the people of Guam and against the crime victims, and that's who I'm here for today. If I was on the other side, I might be doing something similar, advocating my clients, but I would not do that in the role as a senator. Because you guys have, like a judge, you guys have a solemn duty to protect the crime victims and to protect the people of Guam. And I see that as being a violation and a breach today.
I agree, and I just want to further note for the record that it was stated that Attorney Fisher's priority was to his clients in this hearing. So, Madam Chair, nothing further, and Sidos Masi.
Book low-cost flights now.
Nothing further, and Sidos Masi.
Thank you very much, Senator Barnett. If there are no further comments from our panel that's here today, certainly, Senator Fisher, you have the opportunity to provide closing remarks on Bill 306.
Thank you very much, ma'am. Just to address, I guess, the Attorney General and Senator Barnett's concern, this is what's known as a Sandoval hearing. Sandoval. It's a Sandoval hearing. I think that just the quickest possible Google search would indicate where it came from and the history of that. And Senator Barnett is correct. It does come out of New York law. The second concern about whether or not this is organic, I would just like all of us to reflect upon the fact that the rules of evidence that are contained within 6 GCA were also enacted by the legislature, as were the rules of criminal procedure, as were the actual criminal statutes. So if this bill is inorganic, I don't see how any bill that affects the judiciary in any way could be organic, which means essentially we're going to have to open the doors at the Department of Corrections, because everybody up there is being held under an unconstitutional, inorganic procedure. So I know that's a bit of an overstatement to my friend Chris Barnett. I know that's a bit of an overstatement, but I just want him to be, he should just be assured that the bill is in fact not inorganic. So I'd just like to offer that, and then I didn't intend to, I just have to address this idea of that I'm involved in this for pecuniary benefit money, and that I have a conflict of interest by doing this. I think because we're in a public hearing and we're being televised, this is the first time I've ever heard my character for honesty and honor impugned in such a scurrilous way. I hope in the future we're all a little more careful with the hurling of accusations. Mr. Attorney General, I think it will make you feel a little bit better that all of the defense attorney work I am doing is for indigents who cannot afford attorneys. And I am doing so because, as you know, the Chief Justice of Guam Supreme Court spoke at a recent, not too recent, a board meeting for the Public Defenders Service Corporation, and let us all know that there simply were not enough defense attorneys on Guam. We had a situation where there was only, at one point we had a situation where there were only two people addressing the entire indigent defense bar. As a member of the bar, sir, I would offer to you that the reason I have engaged in indigent work is because I feel an obligation as a member of the bar to do so, just as we all have an obligation to provide pro bono services. It is an honor to be admitted to the bar. It is a tremendous honor to be admitted into this legislative body. And I don't know that I can, it's an odd situation where you have to actually stand up and defend your honor. It's not something people usually have to do. But, things arise. But I just would like to assure you, Mr. Attorney General, as well as you, Senator Barnett, that the work I'm undertaking is not for pecuniary gain, rather it is simply to fulfill my obligation to the Guam Bar and to the people of Guam. So thank you for giving me ma'am, thank you for the opportunity of stating that.
Madam Chair, I'd just like to counter that I made no such accusation, that I believe the Attorney General had brought up the subject of financial compensation. I had merely said that maybe the bill was being introduced because of the senator slash attorney's criminal defense buddies may benefit from it, ma'am.
Okay, and with
Madam Senator, I was on the defense bar. I was on the panel. We get paid. So that is the pecuniary gain that I'm talking about. If the good senator is saying that he's not being paid by the judiciary for the work that he's providing, then I will stand corrected. But I mean and we still have to deal with the ethical conflict, but I mean the indigent defense attorneys that are being paid throughout our bar right now are getting paid.
Well, I didn't know that, Attorney General. Senator Fisher
gentlemen,
sound like he was doing it for free out of the goodness of his heart.
Well,
our focus is on this bill. I think we'll suspend any further comment. I thank all of you in the panel. If you have no further comments from coming and providing testimony on Bill 306 as well as the bill earlier 333. For those of you who have testified orally or have not yet testified, the committee will continue to accept written testimony on Bill number 3337 COR and Bill number 306-37 COR.